Joining us now on the program just to discuss this even further is Kelly Hyman. She is a trial attorney. Kelly, good morning.
Good morning. Great to see you.
Of course. Thank you for joining us. Let's just start with the basics here. How difficult is it to bring social media companies to trial and get a case like this and really argue it?
This is a landmark case, and here's why. The plaintiff, who's known by initials KGM, brought a lawsuit against different social media platforms such as Meta, such as YouTube, and alleging that, in fact, the apps are addictive. And because of the being so addictive, that she has been harmed in regards to the fact that she has issues with suicidal thoughts and depression as well. And so this case is going to go to trial. And defendants, the social media companies, have argued that, in fact, first, that based on a Section 230, a law, that they should not be held accountable or liable for what has happened to the plaintiff. However, the judge made a determination that this case, the causes of actions, and those are what the plaintiff brings in this case, are negligence and design defect. And in fact, based on the design defect, that the Section 230 does not apply, and therefore this case is going to go to trial. Now, this has taken many years, and so these type of cases are very hard to get through to the trial point. But now it's there, and this case is going to go to trial.
I mentioned earlier on in this conversation that TikTok actually settled just yesterday out of court before this went on any further. What can we infer by that decision from TikTok, and why is it that Meta and Google have not decided to go that route just yet?
So from the defense standpoint, most likely a cost-benefit analysis of saying whether or not they are going to take this case to trial. Going to trial is very expensive. And so with that consideration, and also we have to remember, when this case goes to trial, a lot of information is going to come out about the defendants and about the design of the app and what they did and what they knew and that kind of knowledge. So a lot of defendants decide, based on that fact, we'd rather resolve this case and settle this case. Now, it's important to remember that this settlement only applies to this case in particular, and there are numerous other lawsuits that have been filed against these defendants.
I want to go back to a point that you just made. And when we talk about these social media platforms, a lot of it is going to have to do with the algorithms and the technology behind all of these apps. Kelly, how difficult would it be to explain to a jury pool the importance of that and to really get them to understand that so that they can make an informed decision?
Experts are going to be key in this case. So the experts can help lay out the facts, and they can also explain their point of view from the plaintiff's perspective of how, in fact, the design, the mechanism of the design of the apps, in fact, are addictive. Now, the defendant will also have an expert to help explain that as well. So the experts are really going to be key in this case to help explain what exactly the app does and does not do.
I want to go back to these plaintiffs there in this case, and let's talk a little bit about the evidence that they're going to have to present in order to argue their case successfully. What is some of the hardest evidence that they're going to need to obtain?
So the plaintiffs bring the case, and what that means is they have the burden and they have to prove every single element of the causes of action. So from the plaintiff's perspective, you definitely see the plaintiff who's going to testify, KGM, and most likely talk about how, in fact, these apps are addictive, because that is definitely key for the plaintiff's case to help show that she became addicted to these apps. Also, experts are going to be key to this case. The experts that can help establish the fact that by using these apps and the way in which the apps were designed, that they in fact were addictive. And then you can also see some kind of mental health, a psychologist, a sociologist, and that's going to help establish the fact that by using these apps, a person becomes addicted to the apps. And so from the defendant's standpoint, defendants are going to poke holes at these arguments and try and say that, in fact, a person makes a choice. When we think about this case, we think about big tobacco, because the whole idea on the big tobacco cases were, in fact, they are addictive, smoking cigarettes, and you become addicted to that. Defendants in this case are going to argue that no, in fact, these apps are not addictive, that people make choices, that people make decisions, that people ultimately decide whether or not they're going to use the app or not.
And I want to talk a little bit about big tobacco, because that is a good comparison. It's the same thing. You have a big company, and then you have plaintiffs alleging that there are addiction issues that are really, kind of beyond the control when it comes to human decision making. When we think about how that was settled with big tobacco or with a similar companies that have faced these kinds of lawsuits, what can we glean from those decisions that could really be implied here? And also, when we talk a little bit broader about the arguments that are going to be made, do you think that maybe we can know where this is going to go? Or is it just so different because it is social media, so it's kind of uncharted territory?
It has a lot of similarities, but of course there's a lot of differences as well. I used to work on the big tobacco cases representing people who used tobacco that was alleged to cause addictive behaviors. So from that general standpoint, in regards to this case and the tobacco case, that is similar, that plaintiffs are arguing, in fact, that by using the apps, you become addicted. So same thing as tobacco. By using the tobacco, a person becomes addicted to it, and you cannot stop. And you cannot stop using it. Now, it's going to be a little bit different in this case because we're talking not about a product itself, but basically an app. So you're going to have more people who are going to explain the technology, the design behind the app as well, because that is going to be key for the plaintiffs. Their main argument is, in fact, that it is addictive, kind of like, gambling, and based on the algorithm that people are constantly strolling or getting notifications. And that's the base of the app itself is what causes the addictive behavior.
And then, Kelly, obviously we're in the beginning stages of this entire case. So I think my final question would be, how quickly would this be able to move to a trial? I mean, how swiftly are we going to go through this entire case going forward?
So right now they're in the jury selection phase of it. So people will come in, they will be asked questions, and then ultimately there's going to be 12 jurors and some alternates. This case is in California. So what that means is that not all the jurors, 12 jurors, have to unanimously agree that the plaintiff wins this case. It is by a majority. So once that happens, the jury is selected. Opening statements happen. The plaintiff and defendant each give their opening statement. And the opening statements are really powerful because usually most people make up their mind during the opening statements of whether or not the plaintiff or the defendant should win. And then people will testify. So this trial is going to go on for many weeks, and then ultimately the jury will make a determination in regards to whether or not to hold the defendants accountable. Now, it's important to remember that this is a civil case and not a criminal case. So in regards to the damages, those are monetary damages, money damages, but also the plaintiff is asking that the defendant redesign the app so it's not addictive.
Kelly Hyman, trial attorney. Of course, we're going to be following this closely. I'm sure you will as well. And we're looking forward to checking in with you and seeing how this progresses. Thank you.